Pilgrim, and with me is my learned friend, Ms. Rashida Edwards, and we appear as before for the appellant.
And I suppose somebody is appearing for the defendant? For
Ms.
the
Davis is judge. She's speaking.
Start over. Okay. May it please the Honorable Court, Olivia Davis, appearing on behalf of the respondent in this matter. I humbly apologize for the absence of Mrs. Crystal Delaney, who cannot join this session, Millard, due to an emergency, sir.
Justice Witt, did you hear Ms. Davis?
Yes, I heard her, so I suppose my colleagues heard it too.
Thank you, Judge.
Okay, I will pass on to Justice Barrow, who will read a summarized version of the judgment that we are giving. Justice Barrow.
Thank you, Chair. The appellant was the sole director of Ouch Boutique Limited, the company, in whose store counterfeit items were sold. The appellant operated the store and was on the premises when the counterfeit items were seized by the police. The appellant was charged with 3 offenses under Section 50A1, A, B, and C of the Trademarks Act, the Act. At the trial in the Magistrates Court, the appellant was found guilty, and he appealed to the Court of Appeal, which dismissed his appeal and affirmed his conviction and sentence. The appellant appealed to this court and argued firstly that the Court of Appeal's decision was wrong, as the charges which were brought against him personally should have been brought against the company. The appellant argued that while in certain cases the courts have pierced the corporate veil and looked behind it to see who controls the company, and in certain circumstances held those persons liable and not the company, this was not a proper case to have done so. The core of the appellant's case was that the separate legal personality of the company protected him, the individual, from personal criminal liability. The appellant did not appeal to the Court of Appeal's finding that he personally performed the physical actions and possessed, at the time, the mental state required to establish the offenses. The appellant argued, secondly, that he was a director, that as he was a director, he should have been charged for being complicit in a crime that was allegedly committed by the company under Section 22(2) of the Interpretation Act, and that the Commissioner of Police should have obtained the direction of the Director of Public Prosecutions before charging him pursuant to Section 22(3) of the Interpretation Act. The respondent argued that the Court of Appeal's decision was correct and that Section 50E1 of the Act provided that an individual may be charged for offenses under Sections 50A1, A, B, and C. The respondent further argued that Section 50E1 and Section 22, subsections 2 and 3 of the Interpretation Act were inapplicable, as the appellant was guilty of having personally contravened the Act, regardless of whether he was liable in his capacity as a director. The court, in a judgment which I authored, was of the view that in respect of the first issue, the appellant was purporting to insert into the criminal law a construct that is quintessentially a company law conception. That company law conception was the legal separation of individuals from the company they formed. The purpose of the legal separation was to insulate or separate the individuals from what they did acting through the company. The essence of that construct was that what was done was the action of the company and not the individuals. The company law conception of separate legal personality never operated to permit an individual who did a criminal act to say that their actions were done in the name of the company, and therefore it was the company which must be prosecuted and not the individual. There is no support, either in principle or in authority, for the appellant's thesis that there is a corporate veil in criminal law. Where an individual acting for and through a company personally performs criminal acts in conducting the company's business, that individual may be prosecuted. The individual gains no protection from the existence of the separate legal personality of the company. There is no principle that a criminal offense committed in the name of a company is the action of the company and not of the individual who performed the criminal actions. Turning to the second issue, the court was of the view that there was no substance to the ground that the appellant should have been charged for being complicit in a crime that was allegedly committed by the company, and that the Commissioner of Police should have obtained the direction of the Director of Public Prosecutions before charging him pursuant to Section 22, subsection 3 of the Interpretation Act. That the appellant could have been so charged under Section 22, subsection 2 of the Interpretation Act absolutely does not give rise to the proposition that he should have been so charged. In a concurring judgment, Justices Witt and Rajnath Lee were of the view that the piercing of the corporate veil doctrine has no place in criminal law proper, statute law having been developed to remove any uncertainty or fill any gaps by providing specifically for criminal responsibility of certain corporate officers who might be successful in hiding behind the corporate facade without such a statutory basis. If criminal liability of the individual person can be attributed to the company, both the individual person and the company may be liable. Both can be prosecuted, but the prosecutor may also choose to prosecute one of them. In this case, the individual person who, according to the magistrate and the Court of Appeal, personally committed the actus reus was prosecuted. The prosecutor simply decided that it was not necessary to go further than that. There was nothing wrong with that decision. Justices Witt and Rajnath Lee also agreed with Justice Barrow that Section 22(2) of the Interpretation Act did not apply in this case. First, Section 22(2) renders a corporate officer of a certain category who had not personally committed an offense committed by that body corporate, nevertheless liable to prosecution as if he had personally committed that offense. In this case, the appellant was prosecuted for offenses he personally did commit and of which he was personally found guilty. This alone excluded the application of Section 22, subsection 2. Second, if the reasoning of the appellant were followed properly, Section 50E of the Act and not Section 22, subsection 2 should be applied. The former provision identifies practically the same corporate officers under similar circumstances as mentioned in subsection 2 of Section 22 as personally guilty of the offense committed by the body corporate, where Section 50E squarely provides that such an officer is guilty of the offense. No as-if situation as contemplated by Section 22 occurs. Third, Section 22, subsection 2, and Section 50E do not cover the same ground, at least not in the same way. But even if they were to conclude that they did, the legal maxim generale specialibus non derogant, or better even its converse, generalibus speciale derogant, would seem to apply. The special later law overrides the older general law. That would be the case here. The appeal was therefore dismissed by virtue of that majority decision. In a dissenting judgment, Justice Burgess was of the view that the Court of Appeal was incorrect in holding that the appellant was properly charged and convicted of committing the charged offenses in his personal capacity on the basis that he acted as an agent of the company. The company, after incorporation, was in law a separate legal person from the appellant, its incorporator and sole director. The company had the capacity, rights, powers, and privileges of an individual. Consequently, the company was fully capable of operating a business, of ownership of goods, of exposing for sale such goods, of having in its possession, custody, or control in the course of business such goods, and of selling such goods. The company, in law, criminally committed the offenses. As a general principle, a director or other similar corporate officer may be held liable for a statutory offense where their company may also be held to have committed that offense. However, this general principle must be read subject to Section 50E1 of the Act and Section 22 of the Interpretation Act. Justice Burgess was of the view that Section 50E1 of the Act, which allows for the prosecution of directors where an offense is committed with the consent or connivance of the director, is triggered where a company has committed an offense under the Act. Section 50E1 applies as long as there is evidence that the company committed the offense. Under Section 50E1, the company is liable for the commission of the offense as a principal, and the director or other corporate officer is liable to be proceeded against and punished as an accessory or secondary party. In this way, Section 50E1 modifies the general principle of the culpability of corporate officers for trademark offenses committed by a company. Section 50E1 must therefore be seen as reforming the general principle and not as merely repeating that principle. Section 50E1 is a veil-piercing provision and must be strictly adhered to. According to the subsection, the consent or connivance or neglect of the director or other corporate officer in the offense committed by the company must be alleged and proved. In this case, these things were neither alleged nor proved. Consequently, the appellant should not have been prosecuted as a principal offender and held guilty of the offenses charged, and therefore should not have been punished for them. In analyzing Section 22.2 of the Interpretation Act, Justice Burgess was of the view that it was undeniably a veil-piercing provision, as it allows, 1, for the prosecution of the specified corporate officer as a principal for an offense committed by a company, and 2, for his or her conviction for the commission of such an offense as a principal, provided consent, connivance, or neglect is proved during such prosecution. Section 22, subsection 2 opens the veil of incorporation much wider than Section 50E1. However, respect for the Solomon Principle is maintained in the Interpretation Act by the proviso to Section 22.2 in 22.3, which stipulates to the effect that a specified corporate officer, quote, shall not be charged under subsection 2, except upon the direction of the Director of Public Prosecutions, end of quote. The Section 22, subsection 3 proviso is of signal importance in the jurisprudence of separate legal personality and corporate criminal liability by stipulating that a corporate officer shall not be charged for statutory offenses committed by a company except upon the direction of the Director of Public Prosecutions. Parliament has evinced an unmistakable intention that corporate officers are not to be lightly charged for offenses committed by their companies. Section 22, subsection 2 permits the corporate veil to be lifted and certain corporate officers to be prosecuted for offenses committed by their companies. But by subsection 3 of Section 22, such prosecution can only be pursued on the direction of the Director of Public Prosecutions. Section 22, subsections 2 and 3 of the Interpretation Act, the general provision, was enacted long before Section 50E1 of the Act, the specific provision. Accordingly, the maxim generale specialibus non derogant does not assist the respondent's argument that the general rule in Section 22, 2 and 3 of the Interpretation Act has no application in this case. There is no evidence in this case that the Director of Public Prosecutions gave any directions that the appellant be charged. The absence of such evidence rendered the prosecution of the appellant before the magistrate a nullity. The appellant was not properly charged and therefore prosecuted and convicted for the charged offenses. For those reasons, Justice Burgess, in whose opinion Justice Anderson joined, would have allowed the appeal. Thank you, Chair.
Yes, thank you very much, Justice Barrow. Of course, this is a summarized form and will not be considered part of the text of the judgment. That you will find in the judgment itself. I think this would conclude this particular session, unless there is something to be said, Mr. Pilgrim.
Well, we're grateful to the court and for the scholarship involved in the decision. And I'm just reminded of what a poor student I am, my days at undergrad, because this is the second time that I've rushed to the end of the judgment and started to celebrate, only to have to go back and uncelebrate. But we're grateful to the court, as always.
Yes, well, thank you, Mr. Pilgrim. Of course, you know we have a strong academic stream in our court. So that might be responsible for some of the learning that comes from the judgment. The lady from Council for the State, any remarks? I take it not. So we will conclude.
Yes, Judge, Justice Witch, she said she was grateful to the court.
Okay, well, we take note of that. Thank you very much. Then I think it's on you to close the procedure, Madam Deputy.
Thank you, Mr. Justice Witt. Thank you, Mr. Justice Anderson. Thank you, Madam Justice Rochnott-Lee. Thank you, Mr. Justice Barrow. And thank you, Mr. Justice Burgess. Counsel, thank you very much for your time and your patience. And a special thank you to the staff of the Caribbean Court of Justice, our IT person, Mr. Paul Acqui, for allowing us to have this session today. This court now stands adjourned. Good day to all. Thank you.